the Prevention of Cruelty to the Animals Act 1960. Brief history is that Padma Bhushan Rukmini Devi Arundel, she was a Rajya Sabha member, two-time Rajya Sabha member in 1952 and 1956 from Madras or Chennai constituency. She was the first lady MP of our parliament. And she was the person behind the framing of this legal provision, that is the Prevention of Cruelty to Animals Act 1960. Initially, there was a similar act of 1890 designed by the British people. And this lady, since 1950s to 60s, she was pushing to get this legal provision framed. She was able to get this legal provision framed through the parliament, that is the Prevention of Cruelty to Animals Act 1960. And she was chairperson for the AWBI since 1962 to 86 until her demise. So definitely credit goes to Mrs. Rukmini Devi Arundel, who pushed to get this legal provision designed by our parliament. The basic objective of framing of this legal provision by the parliament is prevention of unnecessary cruelty towards the animals. So that is the theme of the PCA Act. The PCA Act, section by section, I won't go in detail, I will go in brief. It has got 6 chapters. First chapter is preliminary, section 1, 2, and 3. Section 1 gives the title that is the Prevention of Cruelty to Animals Act 1960. To be implemented from the date it has been notified by the state government. Almost all the state governments have notified this act. And when they notified, that is very much available on the website of AWBI. That is the PCA Act, last page, you can find this. Then there are a few very interesting definitions in this act under section 2. I would like to just bring these things in your notice. The first definition of animal. Animal has been defined under this act as all the creatures other than human beings shall be said to be animals. So that means ki animal bole to everybody other than human beings. So that is very important. That as PCA Act, Government of India or state government or the machinery is answerable for the prohibition of the unnecessary cruelty towards all the animals other than human beings. Then second one is very important definition, very interesting definition, that is owner. Under the PCA Act section 2F, the owner has been defined that anybody having possession of the animal, anybody having custody of the animals, maybe with due consent of the animal owner, real owner, or maybe without due consent of a real animal owner, he shall be considered to be owner of the animal in context to this PCA Act. That means even if somebody is a thief and he's stealing a cow or stealing a dog, in context to this PCA Act, he cannot do unnecessary cruelty towards the animal. If he does the violation of this act, he is likely to be punished for this violation. And under section 3 of the duty of the owner has been provided, and that ensures that we have to prevent the unnecessary cruelty to the animals. And here I will like to bring your kind attention that even Supreme Court of India has endorsed this animal right, that animals have got, animal owner is duty bound to ensure that animal gets proper freedom from hunger and thirst and malnutrition. Animal gets freedom from fear and distress. Animal in his possession gets freedom from physical and thermal discomfort. Animal gets freedom from pain, injury, and diseases, and he gets freedom to express its natural behavior. So this has been endorsed by Honorable Supreme Court of India in its landmark verdict that came from SLP number 11686 of 2007, that is Animal Welfare Board of India versus A. Nagaraja. And the verdict was given by Honorable Mr. Justice K.S. Radhakrishnan, Honorable Mr. Justice Pinaki Chandra Ghosh. So this is a Magna Carta verdict of the animal welfare of our country. It is a very important verdict, and Honorable Court has provided in this verdict that these 5 freedoms to the animals are to be read with section 11 of the PCA Act. That means कि under section 3, animal owner is duty bound to ensure these 5 freedoms, ensure proper feeding and care and rear of the animals, And if he fails to abide by his duties, he is likely to get punished under Section 11 of the PCA Act. Even Section 11(2) I like to go. That is very, very important. I'm not going in detail. I'm just going brief. Section 4 talks about the establishment and construction of the AWBI. Section 5 talks about the terms and conditions. These are chapter 2, section 4 to section 10. They give us legal provisions with regards to function, constitution, authorities, powers, regulation, funds of AWBI. Then section 11(1) is very, very important. That gives legal provision. 11(1) says that nobody can do beating of animal, kicking of animal, overriding of animal, overdriving of the animal, overloading of the animal, torture of the animals, or work leading to infirmity or wound or sore to animals, or administering the injurious drug to animals, or conveying through a vehicle where sufficient space has not been provided and an animal is suffering unnecessary pain and cruelty, or anybody is keeping an animal in a very confined receptacle or space that is not sufficient enough so far as height, length, and breadth is concerned, or he's putting the animal on tethering for unreasonably long time, or on a very short or too heavy chains or a rope, or anybody is not providing sufficient exercise to his animal, or not providing proper food, water, and shelter to the animals, or keeping the animals under starvation, or keeping the animal thirsty, or exposing his animal in his possession or custody towards unnecessary pain, making the animal disabled, or not ensuring that animals don't get diseased in the streets, or which may lead to death of the animals, or mutilating the animals, or starving the animals, or overcrowding the animals, or not providing space enough, or using the animal as bait or prey. Plenty of times you must have heard that forest department officers, they have put a living goat or a living animal as prey so that they can catch a tiger or panther. So that is illegal under section 11(1)(m) first. That provides that live animals cannot be used as bait prey, and anybody organizing the animal fights under section 1(m) second, that is a crime. Then there are few more legal provisions I'll bring in your attention, which are the cognizable offense. There are two sorts of offenses. One are offenses which are non-cognizable, one are cognizable. Under section 31 of the PCA Act, there are 4 conditions which are the cognizable offenses, where police will arrest the accused without any warrant. Those are the cognizable offenses. So section 11(1)(l) is where anybody is mutilating an animal or killing an animal, that is a cognizable offense. Or if anybody is organizing animal fights under section 11(1)(n), that is cognizable offense. Under section 11(1)(o), if anybody promoting the shooting competition so that animals may be killed for the public entertainment, that is a cognizable offense. Section 11(1)(l), section 11(1)(n), section 11(1)(o) are the cognizable offenses where police can arrest an accused without any warrant. And section 12 is illegal administration of the oxytocin on animals for the milk letdown. That is again a crime. That is section 12. This too is a cognizable offense where a police officer may arrest the accused without warrant. And other offenses that I was discussing in the last slide, these offenses, these are not cognizable offenses where arrest is not essentially mandated to the police officer. Then these are the various offenses. If an offense has been done under section 11, then first time offense, 50 rupee penalty may be there. Second offense, 100 rupee penalty may be there. These penalties may appear to be quite minuscule as on date. But in 1960, the 50 rupees was a big amount. And again, Government of India is going to amend this PCA Act, then the legal provisions, then these penalty provisions are likely to become quite handsome. There may be 3 months imprisonment, and there may be both the penalties. That means imprisonment as well as fine. Then under section 35, 1, 2, and 3, state government is required to declare the infirmaries where these animals which suffered the unnecessary cruelty. Under section 11(1), animals were booked. Those animals were confiscated by the police, and these confiscated animals are taken in the custody of police and handed over to these infirmaries or Gaushala shelters or shelters being run by SPCAs or animal organizations, state government is required to declare these infirmaries under Section 35, 1, 2, and 3 of the PCA Act. And on conviction, Honorable Court may forfeit the animal forever in favor of government. Under Section 31, Section 11, 1, L, N, and O, that means shooting of animal, injuring animal so that it may get killed, mutilating animal, or organizing animal fight. These are the three cruelty provisions under Section 11, 1. So in those conditions, under Section 31, it will be cognizable. That means arrest without warrant. And on conviction, Honorable Court, Honorable Magistrate may forfeit the animal in favor of government. And Section 35, 4, 5, and 6 are very, very important. I'll discuss in the next slide. Those are also implemented. Section 11, 1, 2 says when owner is failing to abide by its duties that has been provided under Section 3 of the PCA Act and the 5 freedoms that has been explained by Honorable Supreme Court of India, read with Section 11 that I was saying. So in that condition, animal owner may be punished by Honorable Court, imprisonment without option of fine. Animal is likely to be forfeited on conviction by Honorable Court. And under Section 35(4), the animal will be confiscated by the police and temporary custody will be given to the Gaushala shelter or infirmary or shelter run by the NGO or the shelter run by the district SPCA. And the expenses made on the maintenance of the case property animals, feeding of the case property animals, treatment of the case property animals, transportation of the case property animals, those expenses shall be recovered from the accused animal owner. Owner bole to who are having custody of the animals, maybe a driver, maybe a conductor, maybe a thief, maybe a real owner. They are supposed to pay the expenses of the case property animal through Honorable Court on fortnightly basis. And the rates on which the funds will be recovered from the accused animal owner will be decided by the district magistrate on recommendation of the State Animal Welfare Board as per the Care and Maintenance of Case Property Animal 2017. And if in some states, State Animal Welfare Board and district magistrate are not smart enough to declare the rates, then the rates verified and recommended by JVO, Judicial Veterinary Officer, those rates will be recovered from the accused animal owners. And if accused animal owner is not willing to pay the expenses, then the expenses shall be recovered as land revenue, and even sale of the animal may be done by Honorable Court. And if the animal has been injured quite seriously and it is likely to die, and if the judicial veterinary officer feels that it shall be quite cruel to keep the animal alive, then he may recommend for the euthanasia of the animal under Section 13 of the PCA Act. So that is the legal provision. Now I'll discuss Section 13 of the PCA Act. Section 13 says that if a magistrate or police commissioner or SP, he feels that animal has been injured, it will be very cruel to keep the animal alive, without the consent of the animal owner or accused, he may order for the immediate euthanasia. Or if it is not a police officer or magistrate of that level, then even if a constable feels like that, he can get recommendation for judicial veterinary officer of the government veterinary hospital of the area and get the orders from the magistrate to ensure the euthanasia in the prescribed manner. Okay. And the recommendation of the judicial veterinary officer are very important, that whether we have to go for euthanasia or not to go for euthanasia. And Section 13(4) of the PCA Act recommends that no appeal can be made against magistrate or the police commissioner or SP or who makes any decision with regards to euthanasia of animal, euthanasia of the injured animal, despite of the disagreement of the animal owner. So that is 13(4). How we have to go for euthanasia? Here I am just sharing with you the example of cattle. If we have to go for euthanasia of cattle, we have to give chilazine so that animal gets sedated. Then we have to use thiopentone sodium, 90 mg per kg body weight. Within 10 seconds, animal will suffer cardiac block. Or we may go for saturated magnesium sulfate, or we may go for 10% potassium chloride or iodine, or even chlorhexidine cetrimide, that is Savlon. We can go for. But first we have to give proper sedation to the animal through chilazine. That is the law of the land. And this has been recommended by AWI on 25th November 2013. And under the PCA Act, the prescribed manner has been, AWI is official advisory body to Government of India. AWI has given this advisory, and we have to abide by it. Then section 12 talks about the misuse of the oxytocin for milk let down. That is again an offense. And same, the PCA Act section 12 has got the maximum penalty under the PCA Act, where 1,000 rupees may be implemented. In 1960, 1,000 rupees was a too big an amount. Maybe salary of 2 or 3 years of a veterinary doctor in 1960, 1,000 rupees. 2 years imprisonment or both, and forfeiture of the animals in favor of government on conviction. And this offense was cognizable. And again, section 35(4), 35(1), 2, 3, 4, 5, 6 are implemented. That I was discussing in the last slide. Then section 14 to 19, that talks about animal experimentation. These legal provisions is to be implemented by the another statutory body under the PCA Act at a central level, that is CPCSA, Committee for the Purpose of Control and Supervision of Experimentation on Animals. That means directly as a district veterinary officer, you have not to go on front foot until you have consent of CPCSA in the case of experimentation of animals. So that is the legal provision. CPCSA has the authority where penalty may be up to 200 rupees, and in charge of institution is likely to get punished by the court. Animal may be forfeited. That is the legal provision. Section 14 to section 19, they deal with the legal provisions dealing with the experimentation of the animals. Section 20 provides the provision for the penalty, and 29(1) provides the provision of the confiscation of the animal or seizure of the animals on conviction by honorable court. Then section 21 to 25, chapter 5, it talks about the performing animals or exhibitory animals or training of the animals. So one thing you have to be very, very sure about that under section 27A and B of the PCA Act, Army and police are exempted from these legal provisions. And if animals are being exhibited for education or scientific purpose, as it happens in zoo, those are again exempted. Otherwise, without registration with AWVI, nobody can exhibit the animals. And as I was saying, that animal has been defined under section 2O of the PCA Act, that all the creatures on earth other than human beings will be considered to be animals. That means even wildlife is covered under the PCA Act in the definition of animal. So that way, if a forest department is having a zoo and exposing the animals or exhibiting the animals for the public education purpose, that is acceptable because they get a registration from the Central Zoo Authority. So they have a separate set of act. So we have to be sure that they are exempted under this act. And whatsoever we do in the case of circus or film or use of performing animals, or maybe horse races or maybe other issues, we have to do with due consent of AWVI, because Animal Welfare Board of India is the registering authority under this PCA Act. As a state government officers, we are not supposed to move on front foot without taking AWVI in loop. So this section 21 to 27, we have to do anything with keeping AWVI in loop. Directly, we as a PCA member secretary or as a veterinary doctor or as a state government officer, you cannot go on front foot. Legal provisions are same. Penalty will be more, maybe 500 rupees. Imprisonment may be of 3 months or both. Forfeiture may be done by honorable court under section 29 of the PCA Act. And again, section 35, 4, 5, 6, 7, 35, 4, 5, 6, 7 will be implemented, and 35, 1, 2, 3 again. So the same legal provisions with regards to penalty. These are the brief thing we have discussed in brief chapter 1, 2, 3, 4, and 5 up to section 27. Then chapter 6 is the very important, most important chapter of the PCA Act that provides us section 28 to section 41, miscellaneous provisions dealing with animal welfare. Section 28 provides us manner of killing prescribed in a religion. So that I was saying that Telangana and Andhra Pradesh have got Animal Sacrifice Abolition Act, that is state act passed by the Vidhan Sabha. But now as on date, we have got landmark verdict from Honorable Supreme Court of India, that is 881 Gauri Maliki versus Union of India, where Honorable Supreme Court has declared that in the Gadimai Pashubali case, that animal sacrifice for the appeasement of deities is not acceptable, is illegal. And this verdict has been given by Honorable Supreme Court under section 28 of the PCA Act. That we have to have a basic idea. Then section 29, where Honorable Court deprives the animal owner from right to ownership. Honorable Court, as you were discussing, 29(1), where Honorable Court forfeits the animal, seizes the animal in favor of government. Section 30 is the section under the PCA Act that provides us presumption of guilt clause under this PCA Act, where this act says in the case of cows and goats, where animals were slaughtered without authority, that is under section 11.1.3 of the 11.3 of the PCA Act, where food for mankind animal can be slaughtered. That is section 11.3, where animal cruelty is exempted. So if animal is not being slaughtered in a registered slaughterhouse, an animal is being killed, maybe goat or cow, by an accused, and if the skin of the head is still intact with the body, then it shall be considered that animal was killed in a very cruel manner. And in that case, under section 32.1, sub-inspector of the police may seize the animal, and it will be an offense. It will be a cognitive offense under section 31 of the PCA. So now we have come to know that under section 11.1L, 11.1N, 11.1O, section 12, and section 30 of the PCA Act, these are the 5 different conditions where the offense has been declared to be cognizable. Then section 32.2 that says that if animal is exposed to misuse of oxytocin, that is a crime under section 12 of the PCA Act, the same sub-inspector may have authority for search and seizure. And section 34 gives authority to any constable or any authority. Even state government may declare any officer to be authority under section 32 and 34 of the PCA Act. So state government has got its authority to declare anybody, any officer or any even non-government officer to be an authority to act, have power of search and seizure under section 32 and 34 of the PCA Act. Section 34 of the PCA Act provides authority to the inspector or to the constable or any authority declared by state government to go for search and seizure in case of animal cruelty. That is very, very important. Section 33 provides authority to any first-class magistrate or second-class magistrate to issue search warrant. First-class magistrate bole to maybe sub-divisional magistrate, or maybe Tehsildar can issue the search warrant under section 33 of the PCA Act, where he finds that animal cruelty is happening, he can issue search warrant. So that is there. Section 35 provides the legal provision dealing with the care and maintenance of the case property animals, how the expenses are to be recovered from the accused. As I was discussing, under section 35(1), 2, and 3, state governments are supposed to announce the infirmaries, and section 35(4), district magistrates are supposed to announce the rates of the case property animals to be recovered from the accused on recommendation of state animal welfare board, and those are to be recovered from the accused as land revenue. So that is yes. Section 36 gives us limitation of the prosecution. That means if any crime happens under PCA Act, the FIR is to be booked within 3 months. After 3 months, FIR cannot be booked. That is the limitation of the time. Then delegation of the powers to the state government under section 37. This is a section of the PCA Act that has never been used in our Indian history. Never ever any state government has been authorized by Government of India to exercise any powers under the PCA Act. Under 37 of the PCA Act. Section 39 declares us to be public servant under whosoever is exercising the authority under section 34 and IPC. Section 21. Under IPC section 21, he will be considered to be a public servant, and all these public servants exercising their authority under the law shall have indemnity under this PCA Act. That means cases cannot be booked against those authorities, those officers who are exercising their authorities under the law under this act. So that way we can say as vets, we have got indemnity, we have got immunity. Section 41 says about the repeal of the act that was in 1890. Earlier there was an act designed by British people in 1890, the same PCA Act. It was amended in 1960 through the efforts of Mrs. Rukmani Atandale. Section 38 is a very important, or maybe most important section of the PCA Act. Under the section 38, Government of India has got authority to design the rules, various rules. There are 15 rules designed by Government of India under this act. And for violation of the rules under section 38, there may be penalty of 100 rupees and imprisonment of 3 months and forfeiture of the animals on conviction. And same the provisions of section 35 will be implemented. That means expenses are to be recovered from the accused. These are the rules framed by Government of India under the PCA Act. Drought and pack animals rule 1965, Licensing of Animals Rule 1965, Transport of Animals Rule 1978. Those were amended in 2001 and again amended in 2009. Transport of Animals on Food in 2001. Application of Fines Rule 1978. Registration of Cattle Premises Rule 1978. Capture of Animals Rule 1979. Slaughterhouse Rule 2001 amended in 2010. ABC Dog Rules for the Stray Dogs 2001 amended in 2010. SPCA Rule 2001, Regulation of Livestock Market Rule 2017, with the partial stay by Honorable Supreme Court in the 5 sub-rules under this Act. Care and Maintenance of Case Animal Rule 2017, Dog Breeding and Marketing Rule 2017, Pet Shop Rule 2018. One aquarium and fish tank Animal Shop Rule 2017 were designed by Government of India. Those were withdrawn by Government of India. Under this rule, vets were supposed to exercise the authority for the fish, and there is separate 4-year degree program for the fisheries. Vets were not very well acquainted with the fishes, so that's why Government of India and Animal Husbandry Ministry they withdrew this rules. So we don't have to exercise our authority under these rules. These have been notified by Government of India, but now those have been withheld, have been withdrawn. Then very controversial, Performing Animal Rule 1973. Amended in 2001. In the 1973 rules, focus was on the circus animals. There are few issues with regards to stray cattle. We got landmark verdict from High Court and Supreme Court. Some topics were there: sheltering of stray animals, who shall do, how he shall do, about stray dogs, about abolition of animal sacrifice, slaughterhouses and meat shop is very important. We have got plenty of writs filed in the Supreme Court. Case system of poultry housing, that was challenged in the High Courts, and plenty of High Courts, even Hyderabad High Court also. Now it is being heard by the case has been transferred to Delhi High Court, even Uttarakhand High Court. So that is already with the Supreme Court of India and Delhi High Court. The case is being under trial, under consideration. Then there were plenty of landmark verdicts with regards to poultry farms, with regards to dairies by NGT. Personhood to animal kingdom, that was again a controversy. Some cases are being heard by Honorable Court, Supreme Court, with regards to care and maintenance of case property animals. We have got some landmark verdicts endorsing the legal sanctity of these rules: dog breeding and pet shop rules, livestock market rules. In livestock market rules, some of the legal provisions have been stayed by Honorable Supreme Court. In the livestock market rules, under Rule 22B(3) has been stayed by Supreme Court, where it was prescribed that animals shall not be brought in the livestock market for purpose of slaughter. That was banned. Now that has been stayed by Supreme Court. That means animals can be brought in the livestock market for the purpose of slaughter. Can be brought, can be sold, can be purchased. So that has been 22B(3), 22D(2), that has been 22D(5). That has been stayed by Honorable Supreme Court. And one more thing, that animals shall not be brought for the purpose of sacrifice. That has again been banned by Honorable Supreme Court. So these are the few issues. Then there are issues with regards to resident welfare societies or apartment owners association or dispute between stray feeders and dog layers. Thank you very much.